Good morning, everyone. Welcome to Trial TV Live. I am the Squeegee of Justice. And today is Monday, December 23rd. Let me just check my audio okay, guys? Good morning, everyone. All right, seems like it is. All right, cool. How's everybody doing today? We are going to be picking up on the sentencing of Jerry Burns. But before that, I do want to play the verdict one more time because Friday was a little wonky. We heard it, but we didn't quite see it. So we're going to go back. Thank you, Julie. Audio is good. Therapist, you know. Hellcat, how are you? Good morning. Dream of Landry. Only Fan, Fanny Pack, Merry Christmas week. Yes, hello, hello. Thank you guys for joining us. Appreciate it. Who was first out? Dream of Landry, you win the internet. Fala, Kathy Smith. Glad you guys could all join us. Hellcat. All right, so we'll give people just another minute or so to come in. So today we're going to show the verdict of Jerry Burns, who is on trial for the 1979 offing of Michelle Martinko. She was 18 back in 1979. And Jerry was arrested in 2018, and then this trial is 2020 for those that are just coming in new. This happened in February of 2020. So we made it through, let's see, we made it through every day, and we did watch the verdict on Friday, but it was a little wonky. So we're gonna pick up on that, and then we'll go follow that up with his sentencing. So, Erica Hubner, good morning to you. Oh, Florida PI Sam, how are you? How are you feeling today? I hope you had a good weekend. You had a great show on Saturday, so hope you're feeling good. Hope Henry is okay. All right, so let's do it. Let's get into it. We're gonna go pick up on the verdict. This is only like 4 minutes, and then we'll move on from there. So let me hold on. I gotta pip squeegee myself down. Oops. Pip squeegee myself into the corner, and here we go. Let's pick up. I'll catch you on the other side. This is only 4 minutes.
Good afternoon, members of the jury. Our court attendant informed me that you have reached a verdict. Is that correct?
That is correct.
Okay, if you would please hand that verdict form to Ms. Larson. Thank you. The verdict appears to be in order. The members of the jury, through the foreman, have signed verdict form number 1. We, the jury, find the defendant, Jerry Lynn Burns, guilty of the charge of murder in the first degree, dated this 24th day of February 2020, signed by the foreman of the jury, Mr. Lynch. I will now poll the jury. I'm going to ask you simply whether this is your verdict. Rather than name each of your names, I am going to proceed by seat number, and it will be in the order, the top seat on my right. We will go through that top row, and then we will proceed in the front row of jurors, beginning again to my right, nearest the back wall of the courtroom. Juror number 1, is this your verdict? Juror number 2, is this your verdict?
Yes.
Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict?
Yes.
Juror number 5, is this your verdict?
Yes.
Juror number 6, is this your verdict? Juror number 7, is this your verdict?
Yes.
Juror number 8, is this your verdict?
Yes.
Juror number 9, is this your verdict?
Yes.
Juror number 10, is this your verdict?
Yes.
Juror number 11, is this your verdict?
Yes.
Juror number 12, is this your verdict? Ladies and gentlemen of the jury, thank you again. At this time, we will excuse you. I will be in just a few minutes to thank you again and answer any questions that you have.
Please rise for the jury.
The record should reflect that Mr. Burns, as well as counsel, have remained in open court. The jury has retired again to the deliberation room. I will schedule a sentencing in this matter in the normal course. It will be approximately 6 weeks from now. I direct the 6th Judicial District Department of Correctional Services to prepare and file a pre-sentence investigation report and make that available to the attorneys as well as the court with no less than 5 days prior to the date scheduled for sentencing. Mr. Burns, you do have the right to file a motion in arrest of judgment. A motion in arrest of judgment, as well as any motion to seek a new trial, must be filed within 45 days of today's date and at least 5 days prior to the sentencing date that will be scheduled in the normal course. Mr. Spies can certainly answer any questions you have regarding those motions, but those motions are essential and must be filed prior to that sentencing date if you wish to pursue those motions. Anything further that we need? Well, at this point, Mr. Burns will be held without bond, given the fact that this is a forcible felony. Any further record we need at this time, Mr. Maybanks?
No, Your Honor.
Anything further we need at this time, Mr. Spies? Okay, thank you, folks. We will be adjourned.
All right, so I know it's kind of anticlimactic because we did listen to it on Friday, but I wanted to get that fully in. So, all right, so let us move on to his sentencing, as advertised in my thumbnail there. See if we get closed captioning. All right, cool. All right, so this is Jerry Burns' sentencing.
Good afternoon, everyone. Please be seated. The record will show that parties and counsel are present in open court for 2 hearings. Hearing is scheduled this afternoon on Mr. Burns' request for a new trial that has been resisted by the state. Also scheduled for hearing this afternoon is sentencing upon the jury's February 24 guilty verdict finding Mr. Burns guilty of murder in the first degree. So that our record is clear, the court, pursuant to direction from the Iowa Supreme Court, has taken steps to severely limit the population who is present in the courtroom today for these hearings. Pursuant to that direction, the very close members of the Burns family and close family, friends from Michelle Martinko's family have been permitted the ability to be personally present for today's hearing, and there are members of the media here as well. The proceedings have been made available through a series of websites. There has been a live stream. Permission was granted to the media to live stream these proceedings, so it is available to members of the public, and anyone who cares to observe these proceedings is able to do that by way of that live stream connection. In preparation for today's hearing, I have reviewed the motion for new trial filed by Jerry Burns, and I guess before we get started with that, I will state on the record that Jerry Lynn Burns is personally present this afternoon with his attorney Leon Spies. Morgan Hebert is also here as an assistant to Mr. Spies. The state is represented by First Assistant Lynn County Attorney Nicholas Maybanks. Assistant Lynn County Attorney Michael Harris is here, as is investigator Matthew Denlinger. In preparation for this afternoon's hearings, I have reviewed the motion for new trial filed by Jerry Burns on May 29th of 2020, his supplemental motion for new trial filed August 5th of 2020, and also the state's resistance filed on June 17, 2020. The court has also reviewed the briefs and memorandum in support of the motion as well as the resistance in preparation for today's hearing. And we will begin with any statements or argument in support of the motion for new trial and the resistance. Mr. Spies, if you wish to give oral argument, you may at this time.
Thank you, Your Honor. And as instructed by the court, I'll remain seated. Typically, on a day like today, I would wish the court a good afternoon. This is not a good afternoon. Mr. Burns is appearing before you today in urging the court to grant him a new trial. And I will not regurgitate what I've expressed to the court in my written memorandum, but I did want to address a couple of matters that were either brought to the defendant's attention in the response by the government, or to elucidate on some matters that I didn't fully brief in my memorandum. First of all, as the court recalls, I moved for a mistrial during the testimony of State's rebuttal witness Paul Bush. Mr. Bush testified in response to defensive evidence about the scientific conclusions to be drawn from the DNA present at the crime scene attributed to Mr. Burns. During the course of that rebuttal testimony, Mr. Bush was asked by government's counsel to explain the presence of the defendant's blood on Michelle Martinko's dress. In its response to the government's to the defendant's motion for a new trial, it was characterized that this statement was a hypothetical. I didn't perceive it as a hypothetical. I didn't, in recalling from my notes, that it was presented as a hypothetical question, but rather as a statement of fact. And of course, the defendant objected to that. There was some discussion with the court about whether or not the use of the term blood mischaracterized the evidence. I think you concluded that it did mischaracterize the evidence. And we disputed during the course of Dr. Spence's testimony that it was blood, that it didn't have the attributes of blood, and so forth. So this comment, coming as it did during rebuttal testimony at kind of the apex of the trial, we believe was in a position that it not only mischaracterized the evidence, but caused an introduction of an issue, an introduction of a factual issue that could not be dispelled by the court's cautionary instructions. And I grant that the law in Iowa is that the jury is presumed to listen to and abide by the cautionary instructions, but we believe at this point that the bell had been rung and couldn't be unrung, and that accordingly the court should have granted our motion for mistrial. The next matter I wanted to address was our claim in our motion for new trial that false evidence, false testimony was presented by State's witness Michael Allison, and that under the prevailing law dealing with the receipt of false or perjured testimony, that Mr. Burns should be granted a new trial. There's a claim in the response to the motion for mistrial, or the motion for a new trial, that there was no false testimony. but I think that the court can readily discern from the record that we made in support of our motion that Mr. Allison falsely testified that his lawyer, who was an experienced criminal defense lawyer and the assistant United States attorney handling his serious federal criminal prosecution, had made mistakes about the statutory and rule penalties that he was facing. That was plainly false. There was no indication in the hearing transcript that we've offered in evidence in support of our motion that there was any mistake made by experienced lawyers about the penalty that he was facing. Both Mr. Allison and the federal judge were commending the defense lawyer for being compassionate and experienced. Judge Reed acknowledged Mr. Nathan, the defense lawyer in that case, was a very good lawyer. So Mr. Allison's testimony at Mr. Burns's trial that the reason that the plea agreement in his case was scuttled was because his lawyers were mistaken about the penalties, which is plainly false. He also testified during the trial in front of Mr. Burns that the judge did not reject the plea agreement when plainly the transcript in his hearing demonstrated that she did explicitly reject the plea agreement. That testimony was false. He also testified that she had asked him, that she, the federal judge, had asked Mr. Allison if he wanted to keep it, and he told her no and left it up to him. Well, first of all, if the plea agreement was defective because it was wrong, she wouldn't have given him the option to accept it. So that testimony was false. He also said that she preferred that he not keep the deal. That plainly was not a matter of evidence in the transcript that we've submitted. So these lies by Mr. Allison were critical. And why were they critical? Because they went to his credibility. They went to his appreciation for the stature of this court. It went to the appreciation for his stature, his understanding of the stature of the federal court. He lied about it, and the lies were material. Now, the government contends that these misrepresentations, if they were misrepresentations or lies, were not material. Well, the credibility of a witness, especially the credibility of this witness, was extremely important to the government's case. And the credibility of any witness, and more importantly, what the state knew about the credibility of that witness, is of constitutional significance. It is plain that the prosecution in Mr. Burns' case, in any case, has an obligation of providing Mr. Burns with exculpatory evidence, including evidence that would tend to impeach or challenge the credibility of a state's witness. We believe that experienced lawyers in this case would have been informed by the Assistant United States Attorney, by Mr. Allison's attorney, about the true texture of the legal position he was in federal court, and that failing to correct the falsehoods that I've just enumerated represented a denial of Mr. Burns' right to a fair trial. The next matter I'd like to address briefly is our claim that there is newly discovered evidence that, if brought to the attention of the jury, would have a probable impact on the verdict in this case. The evidence comes from a woman who, in 1979, recalls that she was providing Michelle Martinko with music lessons or organ lessons at a studio in the Westdale Mall, that she had a regularly scheduled lesson on the night of her murder. She attended that lesson, and after attending that lesson, when the witness believed that someone may have been waiting for her out in the hallway of the mall, left the music studio carrying 2 music books and an assignment book. These music books and assignment book were never located at the crime scene. Why do we think that this is material? Well, first of all, as we've argued in our motion, we believe that this evidence, had it been presented to the jury, would have demonstrated that there were actions that Ms. Martinko took the night of her death different than those described by the witnesses brought by the prosecution. Furthermore, because these music books and this assignment book were never located, never seen in the car, never seen in the parking lot that was examined by investigators, that the whereabouts of the attack that Ms. Martinko sustained may have been someplace other than at the car. The fatal wounds obviously were inflicted there, but she may have been assaulted, abducted someplace else. So we believe this evidence is germane, it's important, and had it been brought to the jury's attention, it would have cast doubt on the theory of the government that Mr. Burns traveled from Manchester, Iowa, or from Elkader, Iowa, drove to the Westdale Mall, armed with rubber gloves and a knife, and inflicted the fatal injuries on someone he had no knowledge of. More importantly, we think that this evidence would demonstrate that someone knew about the regularly scheduled music lessons that Ms. Martinko took, knew her actions, knew her routine, and was able to wait for her that night. So for those reasons, Your Honor, and those voiced in our motion and more particularly described in our memorandum, we urge this court to find that error has been committed. Now, we've also, of course, urged the court to re-examine its ruling upon our motion to suppress, and a full record was made in that respect, and I'm not going to recap our arguments in support of that. Finally, given the unusual nature of the evidence here, we're asking the court to find that the greater weight, that the weight of the evidence in this case preponderates significantly against a finding of guilt, and that as a matter of justice and as a matter of fairness, you should find that the evidence is not sufficient to warrant a finding of guilt and a sentence to be imposed against Mr. Burns. Thank you.
Thank you, Mr. Steves. Mr. Maybank, argument in support of the state's resistance to the motion for new trial.
Yes, thank you, Your Honor. And can you hear me okay? All right, good. Well, unless the court wants to or has questions or concerns about any of the issues that Mr. Spies didn't discuss that he brought up, the state would rely on its arguments that it set forth in the written brief for those matters, but would be happy to entertain any questions the court may have about the state's position on that. We believe our positions were made fairly clear on those other items. So I'll just take a little bit of time to address what Mr. Spies brought up here verbally today regarding what I counted was 4 areas that he focused on. First, the motion for mistrial that was made during the state's rebuttal case involving witness Paul Bush. At the time that question was made, the state believes the record would reflect that Mr. Bush was being called for a proper rebuttal purpose, in that Dr. Michael Spence had just testified for the defense on various ways or hypothetical ways that the DNA of Mr. Burns could have been secondarily transferred to the crime scene, specifically Ms. Martinko's dress and the gear shift selector. So in laying out not only the hypothetical supported by the evidence in the case that was also supported by not only the state's witnesses but Dr. Pence himself, when he said the most likely scenario would be direct transfer, the state was also addressing a reoccurring theme that the defendant had brought up during the course of this case, that the source of the biologic DNA that was present at the crime scene, that other sources other than blood could not be ruled out. So the state was addressing that squarely by pointing out, as the evidence did support, that the only substance that tested positive in that biologic specimen that can be confirmed to be present was blood. So in that sense, when the state did indicate Mr. Burns' blood in that hypothetical was not a misstatement or mischaracterization of the record. I don't believe that's what the court found when it admonished, because the objection was ultimately overruled. But if that was the finding, or if the court would revisit that finding, the state would understand that, although we don't concede it was a mischaracterization. We believe that it was proper for us to pose a hypothetical in response to the defense expert witness, that it was based upon not only direct testimony in the evidence of the presumptive test of the biologic material being positive for blood, but also supported by the evidence as a whole in the record, a scenario that was set forth in that proper hypothetical question. Basically, Your Honor, the defendant was allowed to pose several questions that supported his interpretation of the physical evidence in this case to Dr. Pence and to numerous state witnesses. The state merely took the evidence that was supported in the record and posed a hypothetical to Mr. Bush under those circumstances. Whether you want to call it a hypothetical question or not, that was the spirit and nature of the testimony. In any event, the court clearly took action to address the concerns that Mr. Spies had and instructed the jury on what the evidence did show at that time, which was brought out by the state in the defense, not only during the trial but during closing arguments, that, yeah, there was other specimens couldn't be ruled out as being a source of the biologic DNA, but the evidence supported the fact that it was blood, and that's what the state was fairly allowed to argue. And under the circumstances, the court did tell the jury that. It was reiterated, so in that sense, there was no shocking revelation in this question, that the state believed that the biologic evidence at the crime scene containing the defendant's DNA was blood. That was the theory all along. There wasn't a bell that could be unrun. It was something that was very well known. And in that sense, it was addressed by the court. It wasn't improper to begin with, and it was addressed by the court. So we ask that the court find that at least the defense motion for mistrial on that ground be overruled. Second, with regard to Mr. Allison, it took the state a little bit of time to figure out exactly what the defendant was claiming and that Mr. Allison said while he testified that was false. But I think that we did, and it was reiterated by Mr. Spies today, at least what they claimed that he said in this case that was false. And I think that was just an indication of how unclear it was that Mr. Allison said anything false. To support the defendant's argument that prosecutorial misconduct took place, the court would first need to find that there was a false statement made. In support of that contention, the defense found and presented to the court a transcript from a hearing that took place in federal court that wasn't really a plea hearing. It was a hearing that was called by Judge Reed to explain to the defendant that she was not inclined to accept the plea agreement that he had reached, and explained all her reasons, therefore, that she was not inclined to accept that. If you look at the transcript, Judge Reed talks about the whole hearing, and Mr. Allison says two words. And that was in response to Judge Reed saying that Mr. Nathan, his attorney at the time, cared about his clients. And Mr. Allison said, I agree. Now, the jump the defense wants you to make today is that based on what Judge Reed said and the defendant saying, I agree that my client cares about, or my attorney cares about his clients, that he committed a dastardly act of perjury during this trial that the state was required to correct. Now, there's just a lot of nuances in that. There's a lot of speculation. There's a lot of conjecture that he even told a lie, but even more so that it should be something that the state should have to address. So we don't believe that the evidence showed that Mr. Allison told a lie. Based on what Judge Reed said during the hearing, I think it can be reasonably construed by anybody, sophisticated or novice in the federal system, that it was pretty clear that Judge Reed was rejecting the plea, that she didn't want him to take the plea, and that she could give him a more harsher sentence if he went through with the plea and decided to do that, which are all things that are consistent with what Mr. Allison attempted to explain from a civilian standpoint at the trial. So I think I went into a lot of detail there, but I think that shows that just how complicated that is to make the jump that this was an obvious falsehood, if a falsehood at all, that the state should have to report. So the question that's really being begged here, though, is that the credibility of Mr. Allison would be at stake as a witness primarily if he had a plea agreement in consideration of his testimony against Mr. Burns. And there's no dispute in the record that he had no plea agreement in consideration for his testimony. Anything that's implicit, the law says, based upon what was cited in the state's brief, the law says that just goes to his credibility if there's some implicit suggestion. Mr. Spies took ample amount of time was a very effective cross-examination of Mr. Allison regarding his motives. There was no mystery left for the jury as to what motives, if any, Mr. Allison would have. to testify against Mr. Burns. So this dispute, so to speak, over whether Mr. Allison said something false at the hearing was not germane to his motive to testify because he didn't have a plea agreement. It was not germane to his credibility at all, we contend, but at a minimum, it wasn't germane to his credibility such that it would affect the defense's strategy and would lead likely or probably to a different outcome at trial. It just wasn't significant enough to reach that standard. So for that reason and the reasons set forth in our brief, we contend that there was no falsehood, and even if there was no duty for the prosecution to report it, and finally that even if there was a falsehood and there was a duty, it wasn't material enough to affect the outcome of the proceedings. Third, the newly discovered evidence claim. The state took a lot of time in its brief in response to address this. I think the court's well aware of the standard. Our argument starts on page 21 of our brief, and essentially what we're focusing on here is that the defense cannot establish that this newly discovered evidence is material to the case, or that the evidence probably would have changed the result of the trial. Judge, the materiality test requires that there's a reasonable probability there would have been a different result at trial, and the defense can't show this in this case. If Ms. Berkey would have been allowed to testify, the jury would have heard that in her words contained in the affidavit that Michelle Martinko had a music lesson, or an organ lesson, at Westdale Mall, that she believed it was the night of Michelle Martinko's murder, that she was dressed up and she had come from a musical banquet, both of which were very public information that I think most people in Cedar Rapids know by now, in that she may have had someone waiting for her, and we don't know whether that person was someone she knew or a stranger, and that she should, her words, have had 2 organ books with her at the time she left. This focus on the organ books, I think, is a red herring, Your Honor, because Ms. Martinko was found in her car. The evidence showed that there was very little doubt that she was killed in her car, and her purse was found in there too. The state fails to follow the logic that somehow, given those circumstances, that a couple of missing music books would have been a bombshell that would have changed the outcome of this case. It quite frankly wouldn't have, and the logic doesn't make sense to reach that point. I think that the jury would also have to believe that for some reason this information evaded law enforcement for 40 years, even though this investigation had gone on for 4 decades and involved multiple witnesses, multiple false leads, some of that came out at trial, and multiple statements given to law enforcement that just didn't pan out. I think Ms. Burke's information would have fallen in that category had it actually come forward, because as we indicated in our brief, there was no information in the investigative file to corroborate any of what Ms. Burke has to say in this case. The jury would have to believe that all of Michelle Martinko's acquaintances that night didn't see her with organ books. She didn't mention going to a lesson, and they didn't see her at a lesson, including Mr. Thomas, who was the last one to bid her goodbye from the mall that night, had nothing to report in that regard. But more importantly, Your Honor, this would have been something that Ms. Martinko's parents most certainly would have reported and would have resulted in an interview. So the believability or credibility of this evidence is in question for those reasons, and also for the reason that our just very brief investigation and over the last 24 hours showed that not only was she not even taking organ lessons at that time, according to her family, she didn't have an organ at her house, and there was no Carmel Lou's House of Music even at Westdale Mall, where these lessons supposedly took place. So to say that had this evidence been brought up, it would have somehow rebutted or overcome the immense amount of evidence of the defendant's guilt is a stretch, Your Honor. It certainly would not have had reasonably led to any kind of different outcome at trial. If it came up, it would have been, we submit to you, dealt with amongst the rest of the evidence and had no major weight whatsoever to it. So with that being said, Judge, we, with regard to the evidence, the argument the defense makes that the jury's verdict was not contrary to the weight of the evidence. Beginning on page 3, we cited a case law that sets forth the court standard, which I'm sure the court is very well aware of, that only in extraordinary cases where the evidence preponderates heavily against the verdict rendered should the court reach a determination that the verdict is contrary to the evidence. In making his argument, the defendant essentially reasserts claims that were made at trial that were either ultimately conceded by the defendant during the trial or were clearly such that, in the words of the courts involved that have reviewed this standard, may present an alternative explanation or an explanation that could be one that could be weighed, but certainly not one that preponderates heavily against the rest of the evidence in the case. So we believe that, that being said, that there was ample evidence of the defendant's guilt, and certainly the defendant has not reached the standard by merely reasserting arguments at trial that there was evidence that preponderates heavily against the verdict. So we're asking the court to deny not only the defense motion for new trial on these grounds, but all the grounds asserted in his motion.
Thank you, Mr. Maynix. Mr. Spies, additional arguments.
Yes, briefly, Your Honor, thank you. Again, concerning the testimony that was elicited during the testimony of Paul Bush, the government says it should come as no surprise that they would denominate the evidence of the location of some of Mr. Burns' DNA as blood. Yeah, it certainly was no surprise, but it was a fighting issue during the course of the trial whether or not the DNA that was extracted from Ms. Martinko's dress or from the gear shift came from blood or whether it came from some other biologic source. And again, I don't think it was posited as a hypothetical. I objected on foundation grounds. The court, I think, agreed that it was a mischaracterization and admonished the jury through a curative instruction. But again, for all the reasons, given the weight of the fact that this was coming during rebuttal testimony to refute the scientific testimony from Dr. Spence, I think caused it to carry undue weight under the circumstances, and that the curative instruction was not sufficient to undo the damage, with all due respect to the court. Concerning Mr. Allison's testimony that he didn't really lie, well, he did, and to say that Judge Reed was not inclined to accept the plea agreement is not the fact. She said explicitly, I rejected the plea agreement flat out. She also said to Mr. Allison, at this point there is no plea, period. And for Mr. Allison to testify in a manner that kind of skimmed the facts or shaved the truth, either way you put it, he was lying. And those lies were material. They went explicitly to his credibility as a witness on someone who was the only witness who was able to say that Mr. Burns allegedly implicated himself in the murder of Michelle Martinko. Concerning the new evidence, the government again alleges that it wasn't material, that it was. The fact that the witness, Ms. Berkey, had a specific recollection about the number of books that Michelle Martinko would have taken to her during her lesson was pretty graphic of her recall. Also, her being surprised that she had never been questioned about Ms. Martinko by law enforcement. And the reason this is all important is because it demonstrates that Ms. Martinko had a routine, and that routine would have been something that someone familiar with her would know. We know from the manner in which the wounds were inflicted that these were intended to disfigure, that they were personal, and all the more of an indication that someone who knew her whereabouts, knew her routine, knew where to find her, had a reason to kill her, not someone who would drive from an hour away on a night when there was no reason that he would expect to find her or anyone else to inflict fatal wounds, makes it all the more material. Again, Your Honor, we think for all those reasons, and either individually or cumulatively, warrant your deciding today that Mr. Burns is entitled to a new trial, unimpeded by the errors that were made during the course of the trial and unimpeded by the falsity that was injected into this trial.
Thank you, Mr. Steves. Anything further on behalf of the state with regard to the motion for new trial?
No, Your Honor.
Okay. Again, in the interest of making sure that our record is clear, under the rules of criminal procedure, the motion for new trial, the first one was filed on May 29 of 2020. There was some consultation between counsel and the court regarding the requirement of the rules of procedure that that motion be heard within 30 days of its filing. We had some discussion by way of email. Both sides, the defense and the state, filed documentation with the court indicating they felt that given the COVID-19 pandemic that there was good cause. I did make a specific finding that we would hear that motion at a later time, and I just want to make sure that that is very clear in our record, that today's hearing is taking place in the manner that it is because of the COVID-19 pandemic, and the timing of this hearing is because of the concerns with the COVID-19, and that I find that we are hearing this in a timely fashion and that there won't be any prejudice due to the timing of today's hearing. The court will go through paragraph by paragraph the motion for new trial that was filed by Jerry Lynn Burns, the first of which was filed on May 29 of 2020. Beginning with paragraph number 3, Mr. Burns asks the court to grant a new trial given the court's ruling on motions to suppress that included suppressing, he asked the court to suppress evidence that was seized not only from his person, but from the persons of family members of Mr. Burns. He went on to ask the court to grant a new trial given the fact that the court did not grant the motion to suppress either the physical evidence or his statements made to law enforcement on December 19 of 2018. And the court will stand on the written ruling as well as the statements that were made on the record at the motion to suppress. That motion was lengthy and detailed, and the court entered a written ruling overruling Mr. Burns' motions, and the court will stand on the record on the motion to suppress and overrule the motion for new trial on that ground. In paragraph number 4 of the May 29, 2019 motion for new trial, Mr. Burns asks the court to grant a new trial in light of the court's overruling his motions for judgment of acquittal at the close of the prosecution's case, and again at the close of the evidence at trial. The court will again rely on the rulings made in open court and on the record with regard to each of those motions that the court did overrule and deny, and the motion for new trial based on those grounds overruling the motions for judgment of acquittal will be overruled and denied. Mr. Burns goes on in paragraph number 5 to urge the court to find that the jury's verdict was contrary to the weight of the evidence. This is the standard for the court to consider when hearing a motion for new trial, is to make a determination whether the verdict is contrary to the weight of the evidence or contrary to the law. I will make a finding at this time and again at the conclusion of my comments on this regarding my view of the weight of the evidence, and specifically with regard to paragraph number 5, I find that there has not been a miscarriage of justice and that the weight of the evidence supports the jury's verdict in this case. In paragraph number 6 of the May 29 filing, Mr. Burns urges the court to grant a new trial based on the fact that the court overruled a challenge pursuant to Batson versus Kentucky with regard to strikes made by the state in jury selection. The court will again, my recollection is that we had a lengthy discussion. There was a detailed record in the course of jury selection, and the court made a detailed ruling on the record in the process of the jury selection, and the court will rely on that record in overruling the motion for new trial on that ground. With regard to the motion for mistrial in Paul Bush's testimony during the state's rebuttal case, the court redirected Mr. Maybanks to rephrase the question, excluding the specific word blood. That question was rephrased and put again to Mr. Bush, and the court admonished the jury, and the court will again stand on the record that is contained in the trial transcript with regard to that motion for mistrial, and that ground for in the motion for a new trial will also be overruled and denied. With regard to the testimony from Michael Allison, Mr. Allison was certainly subjected to a vigorous and thorough cross-examination by Mr. Spies on behalf of Mr. Burns. The court is not persuaded at this point. I have reviewed the transcript from the what struck me as a slightly unusual hearing that the court called in order specifically to have a conversation with Mr. Allison about the court's reason for refusing to proceed with the plea agreement. But I did review that transcript, and by my notes in the trial, Mr. Allison, I would agree Mr. Allison either didn't understand exactly what was happening, or he wanted to believe that the judge was somehow on his side. However, I have reviewed my notes from the trial, and Mr. Allison was certainly put through his paces, and Mr. Spies conducted a very thorough and vigorous cross-examination of Mr. Allison, and I believe that there wouldn't have been any question about Mr. Allison's truth or veracity at the conclusion of that cross-examination. In paragraph number 9, paragraphs 9, 10, and 11, Mr. Burns raises error or asserts that the court erred in overruling his requests for certain jury instructions. The court and counsel conducted a lengthy informal conference regarding jury instructions. We then had a lengthy on-record discussion regarding proposed instructions, and then the court conducted, again on the record, a formal ruling regarding which instructions would be submitted to the jurors, and the court will again stand on the findings made and the determinations made in the course of the trial, and the grounds raised in paragraphs 8, 9, and 10 in the May 29th, 2020 motion for new trial, 9, 10, and 11 will be overruled for the reasons stated in the instruction conference that took place during the trial in February. With regard to the claim that there has been newly discovered evidence, as the parties are aware, if a defendant seeks a new trial based on newly discovered evidence, the defendant must show that the evidence was discovered after the verdict, that box has been checked. The defendant must also show that the evidence could not have been discovered earlier in the exercise of due diligence, The record at this point has no indication that evidence couldn't have been discovered in a timely fashion in the exercise of due diligence. The defendant must then go on to show that the evidence is material and not merely cumulative or impeaching, and that the evidence probably would have changed the result of the trial. And based on the record before the court today, as I stated, there has been no showing that this evidence could have been discovered earlier through the exercise of due diligence, and I am not persuaded that the testimony, if it had been presented in the manner in which it is shown to us by way of affidavit, that it would have probably changed the result of the trial. So for those reasons, at this time, the court will overrule and deny the motion for new trial and the supplemental motion for new trial. And at this time, if there are no other legal causes to prevent us from proceeding to sentencing, we will proceed to sentencing. Do you know of any other legal cause, Mr. Spies, that we cannot proceed to sentencing?
Only one matter that I'd like to address to the court, Your Honor. That is in filing the memorandum in support of our motion for new trial, there were 3 attachments, post-trial exhibits A, B, and C, and I would formally offer those into evidence. Even though they've been filed, I would ask that they be received as evidence in support of the motion.
Mr. Maybanks or Mr. Harris, do you have any objection? Defendant's post-trial exhibit C that was attached to the August 5th memorandum in support of the motion for new trial is an email exchange between Mr. Spies and, I'm probably going to get the name wrong, Sean Wadey?
I think it's just Wade.
From the U.S. Attorney's Office. Defendant's B is, I believe, the transcript of the colloquy or the record made by Judge Reed in the United States District Court on January 15 of 2020. And Exhibit A is the affidavit of Terry Klooster. I assume that the state has had an opportunity to review those proposed exhibits.
Yes, Your Honor.
Objection to the court receiving those and formally making them part of the sentencing or the hearing on the motion for new trial?
No, Your Honor.
The court will receive those defendants' exhibits A, B, and C and make them part of the record this afternoon. Any other legal cause why we cannot proceed with sentencing at this point, Mr. Spies?
No, Your Honor.
Okay. And Mr. Maybanks, do you know of any legal cause the court cannot proceed to sentencing in light of the ruling on the motion for new trial?
No, Your Honor.
Mr. Maybanks, does the state have comments regarding a sentencing at this time?
Yes, Your Honor. Your Honor, the verdict in the sentence now that you are about to impose, the state believes will give closure and peace to the family and the many friends of Michelle Martinko that have longed for justice for her for 4 decades. And it also will provide enormous relief for our community. A parent's worst fear is sending their child out into the world and having that child never come back to them. And this is the fear that was impaled in the hearts of mothers and fathers across this community for decades. To add to the misery Michelle's parents suffered, they had to live with the fact that she was brutally and senselessly murdered. I don't think we'll ever be able to appreciate what her parents went through. And nobody should have to endure that pain. And although we lost Michelle 40 years ago, it's obvious that pain is still very real for a lot of people in this community. We saw her picture and her photo during the trial. And it's clear that just looking at her, in all of her eyes, she'll always be 18. and that when she was 18, there was no doubt the world was hers for the taking, but that Mr. Burns took her from the world. So we'll probably likely never know why he did it, which is also tragic, because this is the type of crime that's so heinous and senseless that it's an assault not only on Ms. Martinko, but on our very human nature. This is the type of crime that would makes us all collectively ask why. Why did it have to happen? Even though we know that there's no answer to that would ever be acceptable. So we're asking the court to impose today the mandatory sentence in this case of life in prison without the possibility of parole, and also to impose the required restitution to the victim's family. Mr. Burns will have the rest of his life to ask for forgiveness and beg for mercy, but even if he doesn't, we believe that as a result of this trial and the sentence today, at least he won't be able to block it out anymore. Because this moment has finally came for the community and for Mr. Burns. Today is his moment of reckoning, but today it's also the moment of the long-awaited resting in peace for Michelle. With that, we just ask that justice be served, Your Honor.
Thank you, Mr. Maybanks. Mr. Spies, your comments regarding sentencing on behalf of Mr. Burns.
Your Honor, as we made clear at the outset of Mr. Burns' trial and throughout, there is no one that has anything but sympathy and heartbreak for the Martinko family. There is no criticism of the effort that was been made by law enforcement to see justice done in her case. But we believe that the justice that was given to Mr. Burns was misdirected. There's another family in this courtroom today whose lives have been changed, Mr. Burns' family, who remain resolute, supportive, committed in his innocence. It is our hope that the justice system that brings us here today will in time bring him back for a new trial, uninfected by the errors that we've alleged in the motion for new trial. We know that the court has no discretion in opposing sentence here today. We only hope that another day will come where Mr. Burns will receive through justice the not guilty verdict that he's entitled to.
Thank you, Mr. Spies. Mr. Burns, we have reached the stage in this sentencing hearing where, pursuant to the rules of criminal procedure, you have the right to address me with any facts or circumstances you think are important and that I should consider before I enter judgment and sentence you today. This isn't to put you on the spot or make you nervous, but pursuant to the rules, if you have anything to say, sir, this is your opportunity to speak.
Thank you, Your Honor. First of all, I'd like to say that somebody else stabbed Michelle to death in that car that night. I don't know who, I don't know why, but I would like to thank my family and friends for their support. Thank you.
Okay. Thank you, Mr. Burns. It's my understanding that Michelle Martinko's sister and brother-in-law have prepared a statement that they would like me to hear. Is that correct, Mr. Maybanks?
It is, Your Honor, and we have a pre-recorded video statement of that. It's going to be broadcast here on this TV. So.
Judge, where would you like the TV placed?
Probably it's going to be easier for me to relocate. I will step down and you can have it right up there. I just want to remind everyone, because this is a recorded statement, I'm not going to require Ms. Thomason to take that down, so I would ask everyone to please be quiet. We'll all listen to the recording, and then we will resume the record when I'm back on the bench.
My name is John Stonebreaker. I'm Janelle Martinko Stonebreaker's husband. Our family spent 39 Christmases under a shadow without answers, a shadow that never left. 39 Christmases. The court can well imagine the shock, anguish, and horror we felt on learning of Michelle's awful death. I'll never forget Michelle's mother, Janet, calling in the early morning hours of December 20th, 1979. She wasn't crying so much as gasping, choking. She could hardly speak. That night she had identified the body of her bloody, torn, broken daughter, her beautiful daughter, her miracle baby born to her at age 44. She faced with strength the terrible tasks of first identifying Michelle's mutilated body, and then calling us in Davenport, but with the most grief-stricken anguish I have ever heard or ever expect to hear. I don't remember much of that day now. What I remember most are the 39 Christmases with our little family, diminished by one, and everyone's brave efforts to be merry and normal, mostly for our boys, Michelle's nephews, year after year. And that year, 1979, Michelle's presents were unopened. Families experience the sudden loss of a loved one every day. Car accidents, heart attacks, 100 other things shattered normal lives in an instant. We understand that, and to that extent, we're no different. What is an order of magnitude worse is the viciousness with which Michelle was taken, and the terrible questions that were never far from our minds: the who and the why. How could anyone hate so much? Someone who did not even know his victim. For us, the answer lies not in hatred. The post-arrest investigation provides the answer. For us now, the answer lies in a deeply selfish, lifelong personal need. A need Mr. Burns kept hidden all his adult life until now. As time passed without an arrest, Janet Martinko became bitter and withdrawn, and pretty much stayed that way. She directed her anger at an old boyfriend of Michelle's, whose DNA proved him innocent. But his innocence seemed to trouble her and confuse her even more. Al, Michelle's father, was more stoic. He suffered more privately. One of his co-workers at Smolikoff's department store said that Al would sometimes just sit at his bench where he repaired watches and silently weep. Before Michelle's death, I'd ask, "How you doing, Al?" He'd always answer, "Mighty fine, mighty fine." I don't remember him saying that afterwards. This court, as an instrument of the law, will soon punish Mr. Burns for taking Michelle's life. But the law cannot punish him for the damage done to her family and loved ones. The law cannot punish him for the terrible shock, shame, pain, and devastation in the innocent lives of the killer's own family and his loved ones. As we have done, they will pick up the pieces of their lives mend them, and go on. We are sad for them. We reach out to them in their sorrow and ours, and wish them well. We deeply regret that Michelle's dad and mom aren't here to know what their surviving daughter knows. That is Mr. Burns, who took Michelle's life, and will forfeit his freedom forever. It helps to know that his world will be a sad little cell, and that Mr. Burns will never again smell the rich, freshly plowed earth of Delaware County, or the new mown hay in the summer. The sights, sounds, and aromas of his world will be very different. Many inmates put a calendar on their wall. They literally mark time putting an X through each day that passes, because they have a goal: freedom. And as their goal gets closer every day, their hope develops. There's satisfaction in making that X every day. Optimism, hope, a future. But Mr. Burns won't do that. He has no hope. He will die alone. Mr. Burns will be given pain medication if he needs it, in a humane gesture to ease his transition from light to darkness. Mr. Burns may receive a sedative to calm him for what lies ahead. His mark on the world and the sum of his life will be a short notice saying, convicted murderer dies in prison. Convicted Martinko murderer dies in prison. Of course, Michelle got no pain medication. She received no sedation to dull the terrible horror, confusion, pain, and panic of what was happening. Just 6 days before Christmas, she died alone. Instead of a loving family at her side, the last face she saw was Jerry Lynn Burns, and it tears our heart out. Judge Hoover, Janelle and I are thankful in another way. We are thankful that she fought so hard. Michelle played a critical role in identifying her own killer. The defensive wounds on her hand show it. She fought so hard that she was able to deflect the killer's knife so that he stabbed himself, leaving the blood that caught him. In a very real way, Michelle became her own best witness. Still, Mr. Jerry Burns was clever enough to steal 39 years of freedom he didn't deserve, and he knows it. And without a hint of shame, he said as much. And in another sense, in the most selfish act a human being is capable of, he stole those 39 years and many more from a sweet, smart, talented girl who never got her chance at college, a career, marriage, children, and by now even grandchildren. While Mr. Burns has been living free without the conscience of a real man, what remains of Michelle rests with Janet and Al Martinko in Cedar Memorial. Your Honor, thanks to the humanity, wisdom, and mercy of the people of Iowa, Mr. Burns cannot be put to death for what he did. We are at peace with that. He receives a grant of mercy from the faceless state of Iowa that Michelle did not. But he will die a little bit every day and in his long nights to come. And there's some justice in that. Mr. Burns went to Westdale Mall to kill, armed with a knife and rubber gloves that he was sure would protect his identity. He picked Michelle out of the crowd of Christmas shoppers that night, stalked her, and killed her. Janelle and I are comforted, and we can all be comforted by the fact that if it wasn't Michelle that night, it would have been some other young woman. And that young woman is surely alive today, well into late middle age, because Michelle is not. It angered us beyond measure to learn that Mr. Burns listed among his regrets that he did not clean up after himself after the murder. He did not regret his act of killing another human being. No. he regretted not doing a better job. And his comment to his cellmate that he thought was so clever, threatening to, quote, take him to the mall if he won again at Pinochle. Beyond hurtful, of course, but in that way he described himself graphically as among the most odious of human beings. We are forever grateful to the people of Cedar Rapids for keeping hope alive for 39 years, to Cedar Rapids law enforcement for their professionalism and endless resolve to see this case through to a resolution, to the Lynn County prosecution team for their effective work, and to the support staff they provided to us. Over these many years, Cedar Rapids has never been far from our thoughts. And it has been a constant comfort to us that Michelle has meant so much to so many. Finally, Your Honor, Mr. Burns will soon board a state van and be removed from civilized society, excised from all of us like an oozing wound. We are cleansed by his absence, and the remaining members of Michelle's family and loved ones are healed by the knowledge that he will never walk free again. Thank you.
Any other impact statements on behalf of the Martinko family?
No, Your Honor.
Okay, thank you. At the risk of repeating myself, I do want to make sure that our record is very clear that with regard to the motion for new trial filed May 29 and supplemented on August 5, 2020, that the court finds that the verdict rendered on February 24, 2020 was contrary neither to the weight of the evidence nor to the law, and that the court finds that the greater amount of the credible evidence supports the jury's verdict. At this time, a judgment will now enter upon the jury's February 24, 2020 verdict, finding Jerry Lynn Burns guilty of murder in the first degree, a Class A felony in violation of Iowa Code Sections 707.1 and 707.2 Code of Iowa. Pursuant to Iowa Code Section 902.1, Jerry Lynn Burns, you are now remanded to the Director of the Iowa Department of Corrections for the rest of your life. The Lynn County Sheriff shall transport Mr. Burns to IMCC Oakdale when there is bed space available. Mr. Burns will receive credit for each day that he spent in the Lynn County Sheriff's custody dating back to his arrest on December 19 of 2018. Pursuant to Iowa Code Section 910.38, Jerry Lynn Burns shall pay a sum of $150,000 to the estate of Michelle Martinko. In the event there is no estate opened, the payment of any monies shall be paid to the heirs of Michelle Martinko. Those heirs shall be determined pursuant to Iowa Code Section 633.210. Pursuant to Iowa Code Section 901.5, subsection 8A, Mr. Burns is ordered to submit to a DNA profile upon request if Mr. Burns has not already done so. The reasons for the court's sentence today are short and very simple. The Iowa legislature prescribes the sentence for a Class A felony. The jury on February 24, 2020 found that the state proved beyond a reasonable doubt each element of murder in the first degree. Therefore, this is a mandatory sentence. There is no possibility of parole. Any costs that are associated with the prosecution of this matter will be assessed to Mr. Burns, in addition to any victim restitution that is later set out in a pecuniary damage statement. The court will order that if there is an additional statement of pecuniary damages, that shall be filed with the court within 30 days of today's date. Mr. Burns, you do have the right to appeal. In order to appeal, you must file a written notice of appeal with the clerk of the Lynn County Court within 30 days of today's date. If you fail to file a timely notice of appeal, the Supreme Court of Iowa will lose jurisdiction to take up any appeal you wish them to examine. As I stated earlier, there is no right to an appeal bond. Any appearance bond will now be exonerated, but Mr. Burns will be held without bond pursuant to Iowa Code Section 811.1. Anything further from the state?
No, Your Honor.
Anything further, Mr. Spies?
Only one matter, Your Honor. The court in its imposition of sentence said that costs would be assessed against Mr. Burns, and I understand this morning that there was a statement filed by the clerk of court not itemizing those costs, but we will be requesting a restitution hearing in accordance with Section 910.3.
So you'll be seeking a restitution hearing?
Yes.
Okay. I couldn't hear you, sorry. All right. We will schedule a hearing on that request. If there is nothing further, we will be adjourned. Parties are excused.
All right, that seems to be it for his sentencing. I'm just going to run over some key points there, but stick around because Brat found us his appeal, which went to the Iowa Supreme Court. So we'll show that next, and that's about 50 minutes. So thank you to one of our fantastic moderators, Brat. All right, so in the sentencing, the defense argued that Michael Allison's testimony, they talked about the plea deal, and then he came back with it. He had a motion to suppress. He wanted to have a new trial for Jerry because of the testimony of Michael Allison. He thought that he was lying under oath with the whole issue with the plea deal that he said that he was working on and didn't have. They discovered some new evidence. Now, this I thought was kind of interesting. There was a woman that in 1979 said that Michelle had regular music lessons. I believe she played organ, and that someone may have been waiting for her. She was carrying 2 music books and an assignment book that was never recovered at the crime scene. I thought that was kind of interesting. What happened to those 3 books, right? If presented, actions taken by Michelle are different from what was presented at trial. She could have been abducted and assaulted somewhere else. Someone knew about the regular scheduled music lesson and waited for Michelle that night. They wanted to re-examine the motion to suppress, and the greater weight preponderates significantly against the finding of guilt. Defense said those wounds were personal and meant to disfigure Michelle. I agree with the personal. Were they meant to disfigure? Yeah, that's obviously subject for debate, and not the course of someone that would drive an hour one way, find her randomly, I guess, and then drive back. So now the state came back in and said the motion for mistrial was because Paul Bush, he was called upon proper rebuttal purposes. That the evidence that DNA had already been brought in. So he was just there to solidify that Jerry's DNA did in fact come from blood. There was no other source that it came from. They talked about Michael Allison. He took time to figure out he took the time to find out what Allison said was false. It was unclear what exactly Allison claimed was false. And they talked about the transcript from the federal court and his plea deal. And Judge Reed didn't want to accept his plea deal, so it was pretty clear that there was no plea agreement in place. Michelle's purse was found in the car, and there's no doubt that she was oft in that car. And he says there's no logic in a few missing items. So then Judge Fay came in, and she said the motion to suppress the evidence that was seized from him and his family was legitimate and lawful. The judge stands by previous ruling, and she'll deny the motion to grant a new trial based on the court overruling an objection. Not quite sure what I meant by that. But anyway, so she denied that. She also denied Michael Allison's that request that his testimony was false, or he lied because he said he had a plea deal, then he didn't say he had a plea deal. So she denied that as well. As far as the newly discovered evidence must show it was discovered after the trial, which she said checks the box. Missing discovery due to lack of due diligence, which she found was not the case, because they did do their due diligence and show that the evidence is material and would change the result of the trial, and she did not find that, so she denied that as well. So then we actually moved on to the actual sentencing. The state asked for the mandatory, which was life without parole plus restitution. The defense didn't really say anyway. He just kept asking for a new trial. Didn't really say there were no lesser included, or what's that, down. That happened with Ashley Benefield, where they not dived down, but something down, meaning they wanted it less than life without parole. Not sure what else would have been less than that, because it wasn't on the table. So then Jerry spoke, and he said 2 things. He said someone else stabbed Michelle that night, and he thanked his family and friends for their support. Didn't say much else. I thought he would be in, I don't know. Didn't say I'm, sorry for your loss to the family. Didn't say any of that, which I thought was kind of weird. So then there was only one impact statement, and that was from John Stonebreaker. He's the brother-in-law of Michelle. He married her sister, Janelle, I believe her name is. And they are still there. They are still alive. So they were at the trial, and they saw it. Michelle's parents, unfortunately, have passed. They passed earlier in the 2000s. And then the Judge Fay said life without parole plus $150,000 to the estate or the heirs of Michelle. So there you go. All right. So now we're going to check out the appeals, which again brought this to us. So let me cue this up. Let me know if you guys have any questions. Hey, Jenny, good to see you in our chat today. Hope you're doing well.
Pleasant.
Okay. All right, so I'll see you on the other side. This is about 50 minutes or so, guys, just so you know. Okay.
The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Welcome to an oral argument by the Iowa Supreme Court. This is not our normal digs, but it is something we do on an annual basis. And we appreciate everyone's attention and their interest. We do, especially the sound guy. We don't typically have this many people watching. And sometimes when we have special audiences like students in high school, we might tell what high school we went to. I must admit and acknowledge we were at the University of Iowa College of Law. So before we get officially started, I'm just going to go up and down, have everybody state where they went to law school. We have good representation in the Midwest, and then I think we've hit each coast, the East Coast and the West Coast. I graduated from Creighton in Omaha.
University of Iowa Law School in 1984.
Yale, 1982. University of Iowa, 2001. Go Hawks.
University of Iowa, 1998.
University of California, Berkeley, 2003.
Drake University, 1998.
I didn't mention my year, 91. All right, thank you. We have one case before us today set for oral argument, State of Iowa versus Jerry Burns. And it looks to me like counsel are ready to proceed. Thank you. It's my understanding that Mr. Curran will begin the argument on behalf of the appellant. You may begin.
Good afternoon. May it please the court, Mr. Buller. My name is Nicholas Curran. I'm an attorney with Kathleen Zellner and Associates, and I represent the defendant appellant Jerry Burns. The issue this case raises is one of extreme importance, and that is whether the federal and state constitutions allow the government to surreptitiously collect and search any free citizen's genetic material without a warrant, without probable cause, and without any particularized suspicion that that individual has committed a crime. The district court below erred by answering that question in the affirmative, based on the notion that an individual abandons any reasonable expectation of privacy in their genetic makeup by going about their day and doing something as simple as leaving behind a drinking straw that they've used at a restaurant. The district court's decision is erroneous for three reasons. First, Mr. Burns had a reasonable expectation of privacy in his genetic material, including the genetic material he left on the straw. Second, the abandonment doctrine does not apply to unavoidably shed DNA. And third, the search of Mr. Burns' DNA without a warrant violates both the Fourth Amendment and Article 1, Section 8 of the Iowa Constitution because the search was both unreasonable and a trespass. So turning to my first point, Mr. Burns had a reasonable expectation of privacy in his genetic material, including the genetic material on the straw. Of course, the threshold question that has to be answered anytime anyone claims protection under either the Fourth Amendment or Article 1, Section 8 is whether or not the individual had a reasonable expectation of privacy in the area that was searched. An individual has a reasonable expectation of privacy if they have a subjective expectation of privacy, and that expectation of privacy is one that society recognizes as reasonable. Now, the Supreme Court has held that the chemical analysis of blood constitutes a search under the Fourth Amendment because the search of an individual's blood has the potential to reveal private medical facts about the individual. Following that precedent and the inherently private nature.
Does it matter in this case if the testing can only reveal limited information? As I understand the process, it's really related to identity only, and there's not much medical information that can be learned.
Your Honor, no, it does not. And the Supreme Court has addressed this issue in a number of different cases, but one that immediately comes to mind is Arizona v. Hicks. So Hicks stands for the proposition that once the government intrudes upon a constitutionally protected space, the nature of any items that are seized during the search has no bearing on whether or not a search has taken place. So if you have a filing cabinet and that filing cabinet is protected by the Fourth Amendment or Article 1, Section 8, the fact that police go through that filing cabinet and pull out an advertising circular with your name and address on it and leave behind a folder labeled medical records does not make that then not a search. A search under the Fourth Amendment and Article 1, Section 8 occurs whenever the police search an area that has the potential to reveal the privacies of life that those amendments and those provisions of the Constitution.
I'm not sure I follow that. I mean, it seems like in that case, there's an expectation of privacy in the thing being searched, and the court says it doesn't matter what you find. Here, I think you're saying something different, is that there's an expectation of privacy created because of the potential to reveal information. It seems your argument seems somewhat circular, right? I mean, if the police say our procedure here is very limited, and it's limited really to the purposes of identifying people, how is this different than a fingerprint?
Well, Your Honor, so a fingerprint has nothing or has the potential only to reveal information pertinent to identity.
Correct.
There's nothing that searching a fingerprint can reveal about a person's medical history, their ancestry, none of the things that a search of an individual's DNA can.
Is there anything in this record that indicates the police learned anything other than identity information about Mr. Burns?
There's nothing in terms of the search of Mr. Burns' DNA. There was information that was culled from the profile that was recovered from the scene, but not as to Mr. Burns specifically, at least not the DNA profile that they pulled from the straw.
Your client wouldn't have any standing to talk about what was pulled from somebody else's file, would they?
No, Your Honor, that's correct. Mr. Burns would not have standing to object to the search of anyone else.
So the answer you just gave to Justice McDonald's question when he said, was anything pulled other than identity for the defendant in this case? The answer is no, right?
That's correct. That is correct, Your Honor.
Do you agree that no warrant would be needed to lift fingerprints off, say if he had left a water glass at the pizza restaurant?
I agree with that, Your Honor.
Well, couldn't we write an opinion that was limited to just getting identity from DNA that would lead to the same result, no warrant necessary?
Well, Your Honor, again, one of the reasons that we have a warrant requirement is because it necessarily describes and limits what it is the police can search. Without a warrant, they have the unfettered discretion to search whatever they want as it relates to that
So
DNA.
what in this record goes beyond the DNA, the junk type of loci that they were using that only identified, that only provided identity information and did not provide medical information?
So, Your Honor, again, the U.S. Supreme Court has established that it's not just what is actually recovered, but it is what the search has the potential to recover. That's why
But that's what I'm asking you. So what does the test that they did, the type of DNA testing that they did, have the potential to recover other than his identity?
So there are, and I would defer to Mr. Wessler on this point, but there are portions of the 20 loci search that they did that encode more than just information relevant to identification.
And so are all the cases that have distinguished Davis on that basis, then are you saying that the technology is now developed enough that Davis is right and those cases were wrong?
Your Honor, I think that certainly it's important that technology as it relates to the collection of DNA keeps advancing. It keeps becoming more and more sensitive. So, you know, they pulled DNA off of Mr. Burns' drinking straw, but I'm leaving DNA on this lectern. We're to the point now to where DNA testing is so sensitive that it could be pulled off of this lectern.
Mr. Curran, you talk about the need for a warrant in order to sort of cabin the scope of the DNA analysis to make it analogous to the fingerprinting situation. Doesn't the Iowa statute already do that for us?
No, Your Honor, it does not. It does not. The statute is not specific enough to, all it does is it says that the police are exempted from
To identify an individual in the course of a criminal investigation by a law enforcement agency. What's wrong with that?
well, Your Honor, so the threshold question is whether or not an individual has a reasonable expectation of privacy in the area that's searched. So that what is being searched here is genetic material.
So doesn't that exception reduce Mr. Burns's expectation of privacy if the statute says that law enforcement can use his DNA to identify people?
No, Your Honor, it does not. So positive law can only help inform what is and what is not a reasonable expectation of privacy. It cannot lower the protections that are provided under the Constitution.
Counsel,
So
if
yes.
if a private party, if a private person were to grab this straw and send it in and have the DNA tested, would there be any private cause of action that Mr. Burns would have against that person?
Yes, Your Honor, the statute would allow for a private cause of action in that regard. A private person could not do what the police did here, which is take an item that Mr. Burns had handled and then search his DNA. That would not be allowed under the statute.
What rights, if any, did Mr. Burns have in the DNA that was left at the crime scene?
Your Honor, that is not an issue that's been briefed before this court because it's not something that he raised before the district court. However, we know from Mincy versus Arizona that there is no general crime scene or murder scene exception to the warrant requirement.
So let's assume a different case where you have sexual abuse or rape and DNA from semen is collected by the hospital. Is it your position then that the police would not be able to analyze that and run it through a database to determine identity?
Your Honor, they absolutely would be able to do that so long as they procured a warrant for that purpose, and a warrant would be easily obtained. I mean, the facts of the crime are going to provide the probable cause necessary for the police to submit that DNA, search that DNA and obtain a profile from it.
Let me see if I can get you to agree with me that this kind of boils down to the identity aspect that seems to be what the state is arguing, that this is just being used to identify a person, to try and find the identity of someone. Think of carpet fibers. When those are found, for example, those samples are sent across the country to different labs that are expert in trying to narrow down what year was that lovely red shag carpet made, whatever it may be. And finally, they might find out an area, a local store that sold it, come to find out, and they narrow it down. It's not much different than what we did here. If it were to be isolated on the identity purpose anyway, doesn't that change your argument?
No, Your Honor, it does not, because there's nothing inherently private or potentially inherently private about a search of carpet fibers. And there's no statute, of course, that would provide for a right to privacy in carpet fibers. And so that's what it makes it distinct from a search of DNA. So I do see that I had relinquished 10 minutes of my time to the ACLU. And so I would like to, unless the court has any additional questions for me, I would like to turn it over to
Thank you.
Mr. West.
My understand. Go ahead.
Can I
Yes,
ask one, please?
you bet.
I want to ask a technical question about your Iowa Constitution claims. It does not appear that they were preserved below. It appears below there was just a general argument that the Iowa Constitution provides more protection than the federal Constitution, as opposed to the very specific arguments that you make about the statute and its interplay with the Iowa Constitution on appeal. I'd just like you to respond to that, please.
Your Honor, I wouldn't disagree with that characterization of the motion. The motion invoked Article 1, Section 8 in trial counsel's memorandum in support of the motion to suppress. He referenced this court's commitment to independently analyzing constitutional claims under the Fourth Amendment and Article 1, Section 8. The trial court invoked the framework for analyzing that claim under Article 1, Section 8, and then determined that the abandonment doctrine applied. So I do believe that that is an issue that's been passed upon by the district court and has been preserved for review.
Thank you. Thank you.
Mr. Wessler.
Thank you, Madam Chief Justice. Good afternoon, Your Honors. May it please the court. Nathan Fried Wessler on behalf of Amici, ACLU of Iowa, ACLU, and Electronic Frontier Foundation. This court should reverse the district court for the three reasons. And I want to just hit them quickly and then respond to a couple of the court's questions and then can elaborate more fully. So one, involuntarily shed DNA is not intentionally abandoned within the meaning of the abandonment doctrine. Two, positive law supports that result, though positive law isn't necessary to it because ground one, I think, is enough to decide this case. And three, Article 1, Section 8 provides independent protection irrespective of what the Fourth Amendment rule is. And I want to address a couple of the court's questions to my colleague. Justice Mansfield, you were asking about the statutory framework and how that might cabin discretion. I think the relevant legislative statement on what law enforcement can do in DNA is in Chapter 81 of the code. And that's significant because it has very specific limitations on and empowerment and limitations around taking DNA samples from people convicted of serious crimes in the state. It's totally silent on the question here of what happens when police surreptitiously follow a free citizen, collect their DNA, and sequence it. I think the law enforcement exception in 729.6, I read as just a statement that consent rule is about private people and look elsewhere in the code to figure out what to do about law enforcement. Well, here, law enforcement's discretion is cabined not at all by statutes, and that I think is a powerful reason why the Fourth Amendment has a role to play in interposing a neutral magistrate with a probable cause showing and a particularity showing to enable that search.
Yeah, but I mean, isn't that other chapter, isn't it kind of apples and oranges because there are provisions in the law for mandatory provision of a DNA sample if you're convicted of a felony, and then, but that's not an investigation. This statute 729.6 says for investigative to identify an individual in the course of a criminal investigation. That's talking about something different, isn't it?
I think it's an exception to the consent requirement that applies to private individuals for sure. But it just begs the question that's exactly the constitutional interpretive question before this court today, which is under what circumstances are law enforcement able to analyze someone's DNA? And we, of course, think that that's with a warrant, both under the expectation of privacy test and the property test. And I want to spend a moment on the property or kind of textual interpretation of both Article 1, Section 8 and the Fourth Amendment, because I think that's one way to respond to this court's series of questions about whether there's a privacy interest in the search that actually happened here. I think there's no question that had law enforcement taken a swab physically to Mr. Burns or any other free person's cheek to take DNA, that would be a search. So the question here is, when a person involuntarily sheds DNA with no volition whatsoever, is that suddenly no longer a search? Have they relinquished their constitutionally recognized interest in our very genetic material?
I think we call that abandonment.
Well, I think the abandonment doctrine is absolutely the doctrine here. I think the most recent statement from this court on what the abandonment doctrine means was in the court's decision in Wright. And then another member of the court agreed on the basic test. Justice Mansfield, I think your formulation in your dissent was probably the most concise. The abandonment doctrine means an act of abandonment plus intent. Here we have neither a volitional act, right? Human beings shed 30 to 40,000 DNA containing cells every week.
And how was he going to get his DNA back from that straw that he abandoned?
Well, that's exactly right. He couldn't because my DNA is on my counsel table. It's on this lectern. It's on that water bottle that I'm definitely putting in the recycling bin later. There's no ability for human beings to avoid shedding our DNA.
Counsel, isn't that true of fingerprints, though? That's the big struggle.
Well, it is true of fingerprints, but of course, the difference is twofold, I think. One, the privacy interest, and I'm happy to address that in a moment. But two, fingerprints are a physical impression. They are not a part of a person. In constitutional terms, right, the Fourth Amendment and Article 1, Section 8 protect our persons, houses, papers, and effects. These are bodily cells, and the question is still the same that I just posed, I think. Once they're involuntarily shed from the body, is it any less of a search of the person? I don't think the abandonment doctrine actually reaches that.
I don't think that was in your brief, that every cell that's ever been shed by a person throughout their, let's say 51 years, all of this trail of DNA throughout my life, back to Missouri, that's all my person constitutionally? Do you think that the framers would accept that?
I absolutely think that the basic difficulty of asking what the framers would think here is that, of course, DNA sequencing material technology didn't exist. And the US Supreme Court has told us time and again now that the purpose of the Fourth Amendment in these digital age searches is to assure preservation of that degree of privacy that existed when the Fourth Amendment was adopted. And nobody could have conceived that by taking a drink from a copper tankard, they would have left their entire genetic makeup behind. Now science is
Assuming the shedding is a big thing, and I can see from the record that that was a big argument made by the state as well as the defense. The state says it was blood. You said it was shedding by you, I mean defense. But in this case, sufficiency of the evidence is also challenged. And in that car, because the state, I think, believes that it probably was blood, but in that car, which belonged to the victim's family, I don't want to remember her name, Martinko, excuse me, I mispronounce it. The car belonged to her father. And yet the evidence did not show any of his shed DNA. So circumstantially, in this case, what do you have to say about that?
Well, I think that, that car was processed in 1979. The state of DNA, I mean, there was no DNA analysis science at that point. So I'm not sure what we can draw.
Well, you're arguing that shed DNA is what we're talking about.
Well, absolutely, Your Honor. I'm not sure what one can draw from the state of processing a crime scene in 1979 for possible DNA collection. But I can tell you that today, geneticists and crime lab technicians are able to analyze very small quantities of DNA.
Counsel, in this record, what's the evidence that the officers went beyond looking for identity in the DNA testing that they did?
I think there's no evidence that they subjectively actually went beyond looking for.
Is or there's
There's not. I think that they were seeking to use it to identify by using the 20 loci that coincide with the CODA system. As a factual matter, that's right. I agree with my friends that is not the constitutional question here for a couple of reasons. One, the Supreme Court has repeatedly explained that the relevant test in judging an expectation of privacy against a search is not the particular information that law enforcement chooses to focus on, but rather their potential to access everything, right? So in Carpenter, for example, what the law enforcement actually used and cared about were 16 individual location points on a few days that coincided to a few robberies. What the court focused on were nearly 13,000 location points spanning 127 days that the government had potential access to because those were in the files. That is what constituted the relevant expectation of privacy to look at.
But in that opinion, the court talked about all of the information that was learned about people, like the entirety of their lives, their daily activities, where they go, who they spend time with, when they do it. Here, even at best case, you're learning part information about somebody's genetic material, some of which is already publicly expressed through phenotype. I mean, it's not particularly private, right? I mean, these scientists can figure out what part of my genetic code is just from the way I look. So if that's true, that seems very different than what the Chief Justice was talking about in Carpenter.
I think that what the Chief Justice was talking about in Carpenter was potential, right? There's nothing in the record there to suggest that law enforcement cared at all where Mr. Carpenter went to church, but you could tell that by looking at the records. And so it was the potential invasion. And here, even if the court wants to focus just on the 20 CODIS loci that law enforcement was focused on for identification, advances in DNA science over the last decade, particularly since the Supreme Court's decision of Maryland v. King, teach us that actually what courts often used to call junk DNA reveals real information about people, about ancestry and ethnicity, and can correlate, sorry, just one last clause, can be correlated to the much more in-depth kinds of profiles that say 23andMe or Ancestry.com, those kind of companies produce, and therefore opening up exactly that whole array of medical proclivities, ancestry, parentage, phenotype, et cetera.
With respect to the Article 1, Section 8 claim, in Wright, the court focused a little bit more on property concepts and positive law. I want to follow up on what the exchange you have with Justice May. Is it your position that the saliva is an effect?
I think that
the meaning of our Constitution.
I think the most straightforward way to view it is as a part of the person, if you're trying to tie it to one of the 4 constitutional terms in Article 1, Section 8. I think it could be seen as an effect. Now, I want to be clear, our argument has nothing to do with seizing the physical straw and securing it, right? That's clearly an effect. That I think was fairly abandoned. The question is the DNA within that saliva. I think it could be viewed as an effect. I view it as part of the person. And I think the relevant question in both cases is, what does positive law say? Here, positive law talks about DNA and genetic information, not about saliva per se, right? So it's really about the analysis at the lab. And what does the abandonment doctrine say? It requires volitional, intentional abandonment, which just as a biological fact, I think does not exist here.
It seems like there may be a point with these surveillance techniques, whether it's cameras, drones, DNA testing, whatnot, that at least under our Constitution, under these property concepts, that maybe the Constitution has limits. And it seems like part of your argument is that the court necessarily has to resolve this question. And maybe this is a legislative issue, that if people are concerned about the misuse of DNA evidence in criminal cases, that's a legislative question and maybe not a judicial or a constitutional one, at least.
Madam Chief Justice, I see I'm beyond time. May I answer?
Yes, go ahead.
Thank you. It may well be preferable in some democratic sense for the legislature to act, but I think what Fourth Amendment and Article 1, Section 8 jurisprudence has told us over and over is that in the absence of a constitutional legislative scheme, it's incumbent on courts to tell us what the Fourth Amendment and Article 1, Section 8 mean. I mean, in Carpenter, there was legislation. That legislation purported to allow law enforcement access to people's cell phone location history without a warrant. And the court said, that's not sufficient. This was a search and Congress got it wrong 2 decades ago. Here's what the rule is. Would it be better for the legislature to address this? Yes, I think that would be great. But the question is here, well into the DNA analysis age, the legislature has left this as a totally to the discretion of law enforcement, whose DNA to seize and search and what to do with it, whether to test the 20 CODIS loci, whether to sequence the whole genome and learn all the facts about a person. The benefit of a warrant, I think it is clearly a search, and the benefit of a warrant is to cabin that search. And for example, to say in a case like this, there was probable cause, potentially, and the government can test for identification, but cannot test for proclivity for Alzheimer's or for parentage. That's exactly the kind of cabining of discretion that the warrant requirement has always been intended to provide. Thank you, Your Honors.
Thank you. Mr. Buller.
May it please the court. To accept the argument put forward by the defendant and by the ACLU is to undo about 150 years worth of criminal forensics. The technology has changed, but what we're talking about in this case has been true of crime scenes going back 150 years. This is the same as the bloody baseball bat found at the brutal homicide scene.
Excuse me, Mr. Buller, would you mind pulling your mic down a little bit?
Sure, I've been vertically challenged in enough courtrooms to know it's a common problem. Is this all right?
There you go.
It's the bloody baseball bat. It's fingerprints, it's hairs on the carpet, it's shoe impressions, it's hairs recovered from a departing criminal. The common thread in all of these is that we're looking for the identity of a suspect.
Well, but counsel, as I understand the state's argument here, it's that once the straw is abandoned, the DNA on it is abandoned also, and it's not a search, right? And so the government can do whatever it wants with it at that point, right? It's not limited to identity. It could look for markers of aggression or mental illness or something else, right?
The state's argument is twofold here, Your Honor. First is that I do think the abandonment theory solves the entire dilemma here. The straw was clearly abandoned. He'd left the restaurant before police approached the table. And to quote a member of the court, trash is trash. This isn't something that we have an expectation of privacy in. I think that solves the inquiry for both the DNA and the straw. But I'm sensitive to the parade of horribles in the ACLU's brief. That's what the Maryland court called it in the Raynor case. I think it's accurate because these are things we think about in our society today. We have concerns about the Orwellian parade of horribles. How do you solve that? Identity is the legislature's choice. That's the word that they put into the statute. I was troubled by the ACLU's argument that law enforcement use of DNA is totally unfettered and totally at the discretion of law enforcement, because that's not true. Iowa Code Section 7.
Counsel, can I interrupt you there when you're talking about how unfettered it is? So in your brief, you talk about that the police obtained and extracted the DNA information solely as a product of the defendant's status as a top suspect. What's the limiting principle that ensures that police are only pulling DNA using this kind of DNA information for top suspects? What's to stop them from following any person, looking up their drivers or their, figuring out what their identity is from their car plate, following them into a restaurant, doesn't like what they look like, takes their straw and then puts them into their database.
Well, I don't think that the law requires they be a top suspect. That happens to be true in this case, and that's the observation made in our brief. But the language used in the code is for identity, and I think that is a
Okay,
sufficient
but in my
limiting principle.
scenario, it's for identity. I don't like what this guy looks like. I'm going to figure out what his name is. I'm going to follow him. I'm going to pick up his straw when he drops it. And then I'm going to put him on my database because he looks like the kind of guy that I think might have done something. I'm trying to find out his identity.
For one thing, that would not be a lawful use of the database unless it was part of a criminal investigation.
And so where's the limiting principle that means it's not what makes it not be a lawful use of the database?
729 is all premised on criminal investigation in
That's criminal
729.6.
investigation. I have a cold case and I'm trying to figure out who it is and I don't like what this guy looks like, but I have no other basis for it. Where is that between the information that the police had about Mr. Burns here and just some random person on the street?
Certainly requires more than a hunch. I would agree with that if we accept that the abandonment theory is not in play. And I do want to reiterate my response to Justice McDermott, which is that is the state's first argument here. The straw was left behind. It was abandoned. It is trash, and there is no constitutional protection for a straw left at a pizza ranch. But if we set that aside to address your question, I think the court could say it requires more than a pure hunch. There must be some reasonable basis for the law enforcement investigation, but that's not a word that appears in our statutes. The legislature has not crafted that test, and contrary to the ACLU's argument, it is not the role of this court to be a super legislature.
Isn't that why we have warrants? Isn't that the purpose of the warrant requirement?
No, the warrant requirement is twofold. It's to balance reasonableness with the involvement of a judge. Throughout our entire history in this country and in this state, there have been warrantless searches. I'm not sure there even is a search in the first place in this case based on the seizure of the straw. That is the state's best argument in my estimation, because it's a straw left at a restaurant. I ate at Quentin's on my way into town today. I walked out without the straw, the napkin that I'd wiped my face with. I wasn't planning to go back and get it. I'm not going to claim it's my property. I certainly don't think it's part of my person, and it's not an effect. It's not covered by the Constitution.
Counsel, when the police retrieved that straw, at that point in their investigation, could they have gotten a warrant to test the DNA?
I'm, of course, hesitant to Monday morning quarterback anyone, but I do think there was probable cause at that point. I think it's reasonable to have anticipated a warrant was not necessary because there was no support in the case law to think it was. And this is good police work. It's almost textbook good police work. You know the limitations of your case. You're trying to tie this up. And the police were sensitive to the fact that there was a point where they would need to get a warrant. And that's when they invaded the person of Mr. Burns.
All right, Mr. Buller, I mean, how do you deal with Carpenter? I mean, it strikes me you have analogous situations in some respects. You have people involuntarily leaving behind kind of a record of where they are and where they've been.
Carpenter's different for a number of reasons. There's, of course, the Stored Communications Act floating in the background. There's some discussion about the third party doctrine. But if I were the court looking to draw a distinction, that's not where I would go. I would land on identity. If the historical cell records were limited to the identity of the user, I don't think Carpenter comes out the same way. It's a much more limited intrusion. In Carpenter, the court talks about invading the privacies of life. You know, it's essentially stalking someone, following them 24/7, 365. Identity is not that. Identity is fingerprints, it's hair, it's fibers recovered from the scene. It's criminal forensics the way we've always used it. It's not this massive invasion of privacy that the ACLU suggests.
But that's a somewhat different argument than abandonment. It seems like the abandonment argument really comes into a lot of difficulty because of Carpenter. And the chief writes about this is essentially, what does he say? It's an intimate part of life. You can't avoid it. Wherever you go, you need your cell phone. That seems very similar to shed DNA. And now maybe there is a distinction on identity and the expectation of privacy, but that abandonment argument seems tough in light of Carpenter, at least for Fourth Amendment purposes. Do you disagree with that?
At the core of your question, I think there are the two streams of Fourth Amendment jurisprudence. There's property rights and there's the expectation of privacy. Sometimes the streams cross and sometimes they do not. What we see in a case like Wright is the court struggling to find which route to go down and which is the best fit. The best fit here is abandonment. I think it's different from Carpenter in that sense because there is no expectation of privacy in what you leave behind at a restaurant.
You opened up the right door. Do we have to overrule, right, for you to be successful in your argument?
You do not, Your Honor. I would suggest that the court should. That is the state's position, is that right is wrongly decided, largely for the reasons set out by the dissent, but also because it invited the kind of argument that we're having today. The discussion about positive law is a difficult one to have, in part because I'm not sure we all share the same vocabulary when we're talking about it. There's been discussion of positive law today, but of course, the majority footnote in Wright expressly disavows that theory of the law. One of the dissent points out that it's never been adopted by a majority or dissenting opinion anywhere in the country. As a practitioner, it leaves me a little befuddled
Yes,
what
but,
to do with
but
that.
counsel, some of those were pre-Carpenter. And Carpenter has, I think, a little different take. The argument that's being made here is DNA is just different, right? By nature of what it reveals and how it is abandoned and collected in such a sort of easy way. Sort of like the court said that cell phones are different, right? That you can seize a cell phone, but you can't actually open it because of what it opens up about that person's life. Isn't DNA sort of similar? I mean, shouldn't we sort of view it through that lens?
No, I reject that DNA is different. The state's position, and this is supported by more than 20 jurisdictions across the country, is that DNA is just the latest version of criminal forensics like fingerprints. But accepting the premise of your question, that there is something different about it.
But can I stop you there? Because it seems like most of the jurisdictions that that oppose Davis did it on the basis that it's only the however many junk loci that are focused on identity. And it seems like technology, at least if you read the ACLU's brief, the things that they're saying, that the technology has actually come a lot farther, so that even with the information from those same loci, you can get much more than identity. So are we catching up to the point where maybe Davis is right?
First, the record doesn't get us to where the ACL's brief wants the court to go in terms of the technology. That argument really wasn't developed below. It wasn't heavily litigated. There's a lot of social science and citation of materials outside the record in the amicus brief. And I recognize that that's what an amicus brief is for, but we're here to decide cases, and that's not.
So what's the record on what was actually developed, or what testing was done on Mr. Burns's DNA here, and what information they got?
Solely testing for identity, just the 20 loci. At an earlier point, it was 13 and 10 loci. That's evolved over time as the FBI's developed different profiling technology.
And so what's the limit there that prohibits the police from going beyond getting identity from those loci?
I think the statute establishes an outer bound. It talks about investigating crime for identity, and that is an outer bound because that's all the police did here. And frankly, it's all I would anticipate the police do.
Counsel, could I just ask about the text of the Fourth Amendment and also the Iowa Constitution? Do you think there's any way to reconcile the defendant's claim with the text of either of those provisions? And particularly, I'd like you to comment on this idea that we're talking about that the DNA as a person.
I can. The Fourth Amendment and Article 1, Section 8 don't reach DNA, at least DNA that is shed in the sense that we're talking about in this case. Person, in effect, have never been understood in the history of this country to mean, for example, sweat that I would have left on a tavern in 1857. That claim is preposterous on its face. So there's no.
Would you agree that blood is person, or is that effect?
It's neither when it's left at a crime scene or abandoned, as the straw was here.
But let's say it's not left at a crime scene. What is blood?
Blood obtained from a person is a person, and the case law is fairly consistent on that. The invasion of the bodily interest is what we're talking about. That's not at play in this case. Justice May, did I finish addressing your question?
I think so. Thank you.
Can you respond directly to counsel's argument that it's not material what the police actually do with the DNA? It's what they could do that's relevant for Fourth Amendment purposes.
I'm not sure that finds much support in the law. And even if it found a support in some other context, I think it ignores the reality of DNA. There isn't a way that you can microscopically down to the nanometer separate that I'm going to take these 20 base pairs and not these other 15 trillion. That's just not something that can happen. So what we're looking at is really that analogy back to fingerprints and back to blood, where we're looking for specific markers to test against a known genetic profile. And we're not talking about anything new. We're talking about criminal forensics the way that it's always been done.
Mr. Buller, I hesitate to get into this, but has the state kind of given up on a good faith exception to the exclusionary rule in Iowa? Because the whole thrust of the argument makes me think this is an area where the law is unsettled and there are reasonable arguments on both sides. And if we were like the federal system and had a good faith exception, then the murder conviction would likely be affirmed and we wouldn't even be worrying about this legal issue.
And Justice Mansfield, I know the court's read enough of my briefs to know I have not given up on the good faith exception, but perhaps the court has in some of its past decisions. That should be revisited. I've argued that personally to this court. I think you find a special interest for good faith in a case like this one. And you see that in Davis, where the court struggled, the court split. There was a real division about how we even look at the question. I think we see some of that in our argument today. That's what the US Supreme Court would say the good faith exception is for. We will run into new issues in constitutional law in this country as technology continues to change. Part of what the good faith exception is for is to let police do good police work. And that is what the police did here. The police did exactly what I would have expected them to do under existing case law. And it will be lawful unless this court departs from existing case law. That's what good faith is intended to protect. I want to talk for a moment about the Iowa Constitution claim and preservation of that issue, which I know the court asked one of my opponents about. The law cannot be in this state that if you whisper Iowa Constitution in the district court, you get a brand new chance to litigate a brand new issue on appeal. Not only is it frustrating to the litigants, it leaves the court without the record it needs to decide these cases.
Well, as you know, I've been on this court 11 years, and during those 11 years, we've been grappling with this. Wouldn't you agree that if the appellant makes a particular argument, asking for a particular result with particular reasoning, and then they say that's an argument we're making under both the Iowa Constitution and the United States Constitution, we can choose to accept that argument under either one? What's wrong with that?
I'll give my first answer in terms of what the existing cases from the court say. And of course, they're all over the board. You have Baldwin, Ochoa, Short, and Gaskins that all give variations on a theme, perhaps, but inconsistent answers about what's expected. What is the harm in dealing with an issue that's briefed for the first time on appeal? I think that's what's at the heart of your question.
I didn't quite mean that. I mean, I think the position has to have been raised below as well. But where I would maybe draw a distinction, I want to ask you about it, is between the situation where the court lands in a position that was not advocated for by anyone. And that's one thing.
Yes.
A separate thing is where the court lands on a position that was advocated for by a party. They raise both the Iowa and United States Constitution. It may be that the court ultimately concludes the United States Constitution does not support that position, but concludes that the Iowa Constitution does. I don't see anything wrong with that.
Yeah, I think there's a distinction between a failure to brief an issue when the court might reach something on its own and the failure to meaningfully preserve an issue. And I'm talking about the latter here. The reference to the Iowa Constitution was we've got an Iowa Constitution, and sometimes the court has done things differently.
If they had been as specific at the trial level as they were in their appellate briefing, what additional or different record would the prosecution have made?
I think if a trespass argument was made below, there would have been additional development of the record. What you see the county attorney develop, and this is reasonable, I would have done the same thing based on the claims made, is a pretty quick talk about how exactly the property was acquired, how the straw was acquired at the restaurant. If he knew that trespass was the theory we were talking about, he might have established, does the restaurant own the straw? Whose ownership interests were in play? How are things normally done at the restaurant?
But Mr. Buller, as I read the arguments that were made below and here, the defendant is arguing in both places that even if the straw was abandoned, there was a separate violation, an unreasonable search and seizure in testing the straw for DNA. And if that argument was made below and we happen to agree with it, I'm not saying we will, but if we do, what's wrong with saying we agree with it under Article 1, Section 8?
with a real narrow reading of what's being argued as your question just did, I think you're probably right, Your Honor, I do. But my concern is that what we see time and time again is this vague reference to the Iowa Constitution and then a dramatically different claim. The two-part test that you reference, I think, is interesting in this case, because I wholesale reject that there are two different Fourth Amendment events here. The state's argument consistently has been that the straw is abandoned. There are no Fourth Amendment events in this case because trash is trash and you have no expectation of privacy and you have no property interest. I mentioned the two rivers of Fourth Amendment jurisprudence. We're not in either of those.
Could you distinguish Skinner?
Sure, I could. Skinner is a tough case to deal with, and it's a long case because it is a complicated one. It's a regulatory case at heart with Fourth Amendment issues read into it. The easiest distinction to draw is that Skinner involves invasion of the body, and it does. It's blood testing, and it's what the court refers to as deep breath testing. It's not just the kind of breathing that hopefully I'm doing at the podium. It's not deep breathing, but it's something more. It invades the body of the person. And the Fourth Amendment and Article 1, Section 8 do have special solace for the person. A straw left at a pizza ranch is not part of the person. Shed DNA is not part of the person. So Skinner can be separated on that basis because we're not talking about bodily integrity. The other piece of Skinner is urinating, and the court does some discussion in Skinner about expectations of privacy surrounding urinating. Obviously, you have a much greater expectation of privacy when you are going to the bathroom versus when you're eating at the pizza ranch and drinking out of your straw. Skinner, to the extent it has any play here, and I'm not sure it does, is distinguished factually because you just don't reach the same kind of issues. There are protected interests in Skinner that are not at play in this case. I would ask this court to affirm the district court and affirm this case because it's nothing different than what we've dealt with before. It is fingerprints, the bloody baseball bat, and the swab from the rape kit. Thank you.
There are a few assertions that the state made regarding the record that I do feel the need to clarify here at the outset. First of all, the notion that police had probable cause or something approaching probable cause to apply for a warrant to search Mr. Burns' DNA prior to its collection of the straw, that's flat out incorrect. They had nothing tying him to the victim, the scene. What they had was information from Parabon Nanolabs, which the state indicated in its briefing was only intended to generate potential leads and not to provide probable cause for a search warrant. The state specifically said in its argument resisting the motion to suppress, as set forth below, the collection and use of the drinking straw provided the necessary probable cause for the search warrant to collect Jerry Burns' DNA. That's on page 18 of our appendix.
Counsel. Okay, he's going to defer to the old guy. If we accept your position, reverse and hold a warrant was required, aren't we going to shut down an important law enforcement tool to solve cold cases and also exonerate some innocent people? Do you get the DNA to connect to the crime scene?
Well, Your Honor, so again, DNA at a crime scene will always be amenable to search because the facts of the crime scene will provide the probable cause necessary for police to secure a warrant. The state talks about a parade of horribles. There is no parade of horribles as it relates to law enforcement's ability to process a crime scene. There will always be probable cause for them to conduct a forensic.
They never would have connected Jerry Burns to the crime scene DNA though, without getting the DNA from the straw, right?
Your Honor, that's correct. But the price of our individual liberty is that in some situations, it's going to restrict what it is police can do.
I'm trying to imagine, how does one ever abandon DNA?
Well, Your Honor, so, and I do want to talk about that for a moment. So the concept of abandonment as it applies to DNA doesn't make any sense whatsoever.
Before you go deep into it, can you answer, is it possible to abandon DNA?
Absolutely, Your Honor. So,
and you're thinking a straw at Pizza Ranch walking out doesn't count?
I apologize. I misinterpreted your question in my mind. The answer to your question is no. So
our DNA is forever protected?
Yes, Your Honor. And if we look at 729.6, that's exactly what the statute provides. Not only does it provide an expectation of privacy in our genetic makeup, but in our unavoidably shed DNA, because it prohibits somebody from taking your shed DNA, unavoidably shed DNA and submitting it for DNA analysis.
But that's not true for law enforcement, and right?
Well, Your Honor, so turning back again, and this is why we have to do this sequentially. The very first step in the analysis is there a reasonable expectation of privacy in DNA?
Why isn't the first question, is this a person or a fact? I mean, we're dealing with constitutional text, and I understand, let's talk about Article 1, Section 8. And right, we indicate that should be the analysis, right? The threshold should be, is this a person? Is this a fact? Is it paper? Is it your house? And I'm really struggling with the concept that discarded DNA and saliva is the equivalent of a person within the meaning of the Constitution.
Your Honor, and that goes back to Skinner. So, and to clarify something that the state said along those lines, it's not just the physical intrusion into the skin to draw the blood that is a search. The court explicitly held that subjecting that blood then to chemical analysis is a second search. So just like searching blood is a search under the Fourth Amendment, so is searching.
But that's a different framework in the federal system. The federal system defines a search as a violation of expectation of privacy. In Wright, we said that's really not the way that we approach the state constitutional question. There's no doubt this was a search.
Correct.
No doubt. Under Wright, the question is it a person or an effect? And what's the case law that would indicate DNA as a person?
Your Honor, I think as it relates to blood, that is a question that's been answered in the affirmative. So if you're looking at, there are similarities between blood and DNA. Blood has the potential, an analysis of blood has the potential to reveal.
Are you talking about blood that's not been pierced through a vein, but just blood found somewhere?
Either, Your Honor. So both blood and DNA, if you subject it to analysis, has the potential to reveal private information about whoever's blood or DNA it is. DNA, much more so than blood, has the potential to reveal a vast array of information that a search of blood could not. And I see I'm out of time, Your Honor.
I have one question.
Sure.
Why doesn't the good faith exception apply here? Why shouldn't it?
Well, Your Honor, that argument was not made by the state below, and it's not been something that's been argued by the state in its brief before this court. And this court has held that at least under Article 1, Section 8, there is no good faith exception to the warrant requirement.
Anyone else? Okay, thank you.
Your Honor.
Case of State versus Burns is hereby submitted. Thank you. The court is adjourned.
Hearing, hearing, the Honorable Supreme Court of the State of Iowa is now adjourned.
All right. Let us recap that. That was the Iowa Supreme Court on the appeal for Jerry Burns, and that was found by our one of our great moderators, Bratt. You can mention the conviction was affirmed by the court. Okay. All right, and Bratt sent me another note. Hoping in your summary at the end you can mention that the conviction was affirmed by the court in case anyone watching wonders whether it was overturned. Okay, so it was affirmed. All right, so let us, maybe I put the cart before the horse there. All right, let's go back to the arguments, which is interesting because there were 4 arguments, but they didn't talk about one of them, actually 2 of them. All right, so the arguments before the Iowa Supreme Court. The trial court erred in denying defendant's motion to suppress where the warrantless extraction of defendant's DNA profile violated his rights under the Fourth Amendment of the U.S. Constitution. Number 2, the trial court erred in denying defendant's motion to suppress where the warrantless extraction of defendant's DNA profile violated his rights under the Article 1, Section 8 of the Iowa Constitution. Now, those two we heard, but then there's 3 other arguments which we did not hear. The trial court's refusal to instruct the jury on the law related to Michael Allison's motive to testify against defendants constitutes a prejudicial abuse of discretion. And then number 4, the evidence was insufficient to support defendant's guilt beyond a reasonable doubt. All right, so those were the 4 things they were arguing, and then they got to 2. Maybe the other 2 were just written. I'm not sure. All right, so let's go to, since the main thing was they were arguing Section 1, Article 1, Section 8 of the Iowa State Constitution. So that is, and I put it in the chat. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable seizures and searches shall not be violated, and no warrant shall issue but on probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons and things to be seized. Okay. So first up was Nicholas Curran, and he talked about the DNA left on the straw, and the search was without a warrant, unreasonable, and was a trespass. He talked about the right of privacy of DNA, and the judge said, how is this different than a fingerprint? And Curran came back with, a fingerprint only provides identity, not medical history or family history. Fair point. The judge then says, does Iowa statute identify fingerprints and DNA already? And he argues that it does not. The judge said, what rights does Burns have at pulling DNA from a crime scene? And they're not arguing that. That they did not argue. They're arguing more, I think, the straw. I think that's what they're arguing. They're not arguing about the blood that was pulled from the crime scene because it's the crime scene. You can't say, no, you can't go in there and take a fingerprint or DNA sample. He's arguing the appeal, I think, basically was the DNA that was pulled from the straw, that was unlawful. And then the judge asked, what about police pulling DNA from an SA victim? And he said, yes, that's valid. Glad he said that. Then he turned his time over to Nathan Wessler, and he brought up, he references the articles, sections, and codes. He argues DNA is everywhere. And the judge said, isn't that true with fingerprints? Then they talked about the privacy rights and DNA as a part of our identity. Once it's shed from a person, isn't that a part of that person? And the judge said, what would the framers think? And then Wessler said, the framers didn't have knowledge of DNA back then. True, fair point. The judge said DNA was blood. Defense says shedding. And then the judge said the car belonged to his father, and there was no DNA shedding found there. So, and then he argued, well, it was good enough to, the DNA was good enough to find Jerry's, but it wasn't good enough to find the father. So again, kind of talking out of both sides of his mouth there. But I thought that was a fair point. They didn't really bring that up in trial. I don't remember that during the course of the trial. I'm sure they did. I just missed that, where they tested for the DNA of the mom and the dad, and I would assume her sister too. And they did not find any DNA other than Michelle and Jerry's DNA. And then Tyler Bueller got up, and he's the appellee, and he's the for the state. So he talked about bloody bat, hair follicle, fingerprints. All of this is you're trying to find the identity. It's not just it's not just DNA. And the judge said it's not limited to identity. And Tyler says, well, the straw was abandoned, and trash is trash. He went to eat at some place, and he left. He wiped his face with a napkin, and he's like, that's out there. It's out there. The judge says, is DNA the same as cell phone in that you need a warrant to seize and then extract that info? And Jerry, he rejected that, and he said there's more than 20 jurisdictions that support that. And then they talked about, who owns the straw? Does the restaurant then own the straw? Do you have to go to the restaurant and get a warrant from the restaurant? Trash is trash. Judge said, even if the straw was abandoned, the search and seizure of the straw is the main issue, which I agree. So then Article 1, Section 8, a straw or skin shed is not part of that person, is what Tyler was arguing. And again, Article 1, Section 8 is the right of the person to be secure in their persons, houses, papers, and effects against unreasonable seizure and searches shall not be violated, and no warrant shall issue but on probable cause and support by oath or affirmation, particularly describing the place to be searched and the persons and things to be seized. So they're saying the straw was unlawfully seized. Then Curran came back, and the judge says, "Is it possible to abandon DNA? Is DNA forever protected?" And he answered, "Yes. Blood and DNA has the potential to reveal private information, but DNA has a vast more potential to reveal, more medical history, genealogy, whereas a fingerprint is just, it's like your voice, or your hair color, So, all right, that pretty much concludes Jerry Burns, you guys. And I love the idea of finding more appellate trials that we've watched, seeing if it goes to the appeal. Oh, and then it was denied. I said that at the beginning of it, but I will say it again. Let's see. The conviction was affirmed by the court. It was not overturned based on those arguments. So, hey, Dreamalandry, thank you. You're welcome for the Christmas music. Yeah, we'll probably play that again on Christmas or something similar to that. So if you guys have any questions, I'm going to sign off soon, and I want to let you know that 4 o'clock today, Jules will be joining me and Nick Starro. He is a fantastic lawyer, and he's going to be joining Jules and I. Jules is going to do a Jules Investigates. She found something that has to do with the Maya Kowalski trial and the lawyers that are involved. So definitely check that out. That's going to be at 4 Eastern today. And then tomorrow, I found a new trial for us to watch. It's a rewatch of The Only Fan in New Hampshire. I thought it looked pretty interesting. What is his name again? Because I just saw it yesterday, or came across it yesterday. Mauricio Guerrero. So this ought to be a good one. So join us tomorrow. We'll pick that up at 9 o'clock tomorrow. And then at 4 o'clock tomorrow, we're going to do our Christmas Eve. We're maybe starting a new tradition. We'll see. Where we're going to have, Florida PI Sam's going to join us. Sneaky Side is going to join us. Jules will join us. My friend Tony will join us. Therapist will join us. Hopefully OnlyFan will join us. So we're going to be starting that at 4 tomorrow. So once again, today after I'm gonna end this stream in a few minutes, but today at 4 Eastern, Jules Investigates with Nick Starro will be on. We'll be talking about Maya Kowalski and some developments there with the lawyers. That's today at 4. And then tomorrow we're going to pick up on a rewatch of Mauricio Guerrero, who's an OnlyFans stalker in New Hampshire. And then tomorrow, which is Christmas Eve at 4, we're going to spend Christmas Eve with some friends and special guests. And we may have some really fun people that you guys all know might be stopping in for a few minutes. So I'm not going to say any names right now, but definitely check that out, because we're going to have some fun friends, people on it. But then we're also going to have some really cool special guests. So I'm hoping they stop by. They are content creators that you guys all know and love. So. Thank you guys for joining Trial TV Live. I am the Squeegee of Justice. I appreciate you all. Stick around or come back at 4 o'clock, another 4 hours or so for Jules Investigates. And then tomorrow we're going to pick up at 9 o'clock and do a rewatch of a new trial. And then we'll do our Christmas Eve stream tomorrow. So thank you guys. Thank you to Aaron, who as always is just rocking it on the background here in the backdrop. Our mods, OnlyFan, Therapist Julie, Brat. Brat brought you the hearing today, so thanks to him for that. Florida PI Sam, Jules, Rachel B. She just moved, so she's really busy. So thank you guys. Merry Christmas to you all. Yeah, thanks for working on Festivus. No problem. So join us today at 4 Eastern. For Jules Investigates, and then tomorrow for a new trial, and then That's at 9, and then 4 o'clock, we will be doing our own little Christmas Eve soiree. So join us, guys. Love you all. Appreciate you all. And we will see you hopefully today at 4 Eastern. Bye.